everybody. My name's Aryeh and I'm here to welcome you all to this UCL Current Legal Problems lecture. I am co-convener of this lecture series and co-editor of Current Legal Problems volumes. And my job really is just to introduce the chair. We're very fortunate to have with us Professor Dame Sarah Worthington to chair this lecture. She is a Professor of Law at LSE, where she recently returned after some years at Cambridge, although is also still Professor at Cambridge, I understand. She specialises in commercial equity, in personal property and corporate law. And she has a wealth of scholarly books, articles and other publications behind her. Her interest in governance and strategy has been reflected in a number of board roles, including currently at the British Museum, Cambridge University Press and the London Business School. She is a Fellow of the British Academy and Chair of their Law section. So we like to talk about the links between practice and academia with these lectures, and I think we can say that Dame Sarah embodies those links, given that she combines her impressive scholarly career with being a Deputy High Court Judge in the Chancery Division. So thank you very much for joining us, Sarah, and I will now hand over to you to introduce our lecturer. Welcome, everybody.
Thank you, Emma. I hope I'm not going to be in the position where that was a longer introduction to the chair of the lecture than I'm going to give for Janet. But it is an enormous pleasure to introduce tonight's lecturer. I know you're all attending because you already know something about Dr. Janet O'Sullivan, and you'll know that she's always worth listening to. You're no doubt also intrigued by the foray of a serious and well-published private lawyer into the arena of gambling addiction, financial disaster, and suicide. It's really the stuff of page-turner novels and Hollywood movies, don't you think? And CLP lectures are always rather special. There's something of a rite of passage for serious scholars, and Janet O'Sullivan is a friend and a colleague of mine in Cambridge, so we can't start without some highlights. I'll keep them short. That seems to be the CLP tradition, not to run into lecture time. But on Janet, she's clever. She's very clever. And she's quick, and she's intellectually agile. She graduated with a triple first in law from Cambridge, and then practiced at Slaughter and May as a commercial lawyer, before returning to Cambridge and to academia. That return has served private law well, especially in the areas of contract and tort, where Janet has published widely. Her well-known textbook on the law of contract is now in its 10th edition. But what marks Janet's scholarship is something a bit different. It's range, its variety, and her ability invariably to deliver interesting, lateral thinking, different takes on modern problems. I'm sure we'll see that tonight. Her scholarship, it seems to me, demonstrates all the advantages that lie in not becoming too specialised. Janet's managed all this scholarship while playing a full role in faculty and college affairs. She's the Vice Master at Selwyn College and the Senior Law Fellow there. She's also the mother of 3 children, one of them with Down syndrome. And from my experience, and this is quite an important trait in academic colleagues, she's often the life and soul of the party. The expression, "I don't know how she does it," was really made for Janet. But that's not the end of her credits. Janet also has a Pilkington Prize for Excellence in Teaching. Probably most of you haven't got a clue what that is. But there are a tiny number of these prizes awarded each year across the entire university in Cambridge. It's the Gold Dust Award for teaching. I'm sure we'll see that skill in evidence tonight. And You won't know quite how she does this, but at the end of her talk, taking about 45 or 50 minutes, you'll not only know more than you know now, you'll understand it. And you'll understand it differently from the usual way the issues are put. So I hand over to Janet to deliver what promises to be a fascinating lecture on a serious modern problem: gambling addiction, financial loss, and suicide, exploring the common law. There'll be time for...
Thank you. Thank you very much, Sarah, for that very generous introduction. Thank you to UCL for inviting me to deliver this lecture, and to everyone who's present in the room here and listening online. So now I need to get my brain around PowerPoint, so I'm not very good at that. So, it's hard to credit, but Britain is a world leader in something: gambling. It's a mainstream leisure entertainment with inescapable advertising, sports sponsorship, honours for its chief executives, profits for its shareholders. The Office of Budget Responsibility estimates that for 2022 to 2023, taxation from gambling will raise £3.3 billion. But this hides a tragic reality. The House of Lords Select Committee on Gambling Harms reported that, on average, one sufferer from pathological gambling addiction or gambling disorder commits suicide every day. While a recent study in Sweden found that men and women with a gambling disorder were 15 times more likely to commit suicide compared to the general population, rising to 19 times more likely in men between the ages of 20 and 49. Gambling disorder is a recognised serious psychiatric illness. Sufferers all too frequently take their own lives. For many, many others, their lives and those around them are blighted by this cruel addiction. The message from the gambling industry is that sufferers have no one to blame but themselves for not gambling responsibly. Contrast the report of the House of Lords Select Committee, which begins with a warning that the unscrupulous methods and ingenuity of some gambling operators make for shocking reading. What I want to ask is, where's the common law in all of this? I'm proud of the common law that Lord Wilson has said recently was built by the judges on behalf of the people over 7 centuries. Traditionally, it has had an important role in responding to new social harms by innovating new forms of civil liability. So in the 19th century, it responded post-industrial revolution to the horrific injuries suffered by factory workers by inventing the tort of breach of statutory duty. While at the turn of the 20th century, it was radical in its recognition of the possibility of liability for what we now call post-traumatic stress disorder and other physical and psychological harms resulting from traumatic shock. In case my equity colleagues feel left out, we can see similar social protection innovated by the Chancery courts, who in the 19th century gave relief against unconscionable bargains to protect penniless young heirs who'd been tempted to trade their future inheritance at a huge undervalue for cash in order to gamble. So why does private law seemingly have no role in protection against harms caused by gambling disorder? Well, to answer that, we need to turn to a very restrictive and influential decision from 15 years ago called Calvert and William Hill Credit Ltd. So in Calvert, the trial judge, Mr. Justice Briggs, as he then was, said something very striking. Oh, trying to go backwards. There we are. He said this: recognition of a common law duty to protect a problem gambler from self-inflicted gambling losses would involve a journey to the outermost reaches of the tort of negligence, into the realms of the truly exceptional. This dictum was quoted with approval by the Court of Appeal in the Calvert case. So my question, the question that prompted this lecture is, why? Why the outermost reaches? Well, let's look at the facts of the case first. Graham Calvert was a greyhound trainer and heavy gambler. After many years betting in various bookmakers, he started in May 2006 telephone betting with William Hill. And as the court said, In periods of calmer lucidity, he was aware that his gambling was at times uncontrolled and potentially destructive. After one particularly destructive betting frenzy in early June, he phoned William Hill and asked to be self-excluded from telephone betting. William Hill offered a 6-month self-exclusion scheme pursuant to its social responsibility code. The relevant senior employee agreed to do so, but then totally failed to implement the self-exclusion procedure. Soon afterwards, therefore, Calvert resumed telephone betting with William Hill, and in the next 6 months, he racked up losses amounting to over £1.9 million because he'd had to resort to expensive borrowing to fund his extraordinary levels of gambling. So he sued William Hill for damages. Though this was mainly framed as a claim for financial loss, the judge accepted that during this 6-month period, Calvert's gambling disorder worsened. He said the claimant had lost control of his gambling by the last quarter of 2006. So the judge allowed an amendment to the claimant's pleading to add a claim for damages for personal injury constituted by the deterioration of his gambling disorder caused by the defendant's breach. Now, how did Calvert plead his case? Well, he pleaded his duty of care part of the case in 2 ways, a broad version and a narrow version. The broad version was as follows. This is the way he pleaded it. That the common law should now recognise a duty of care on the part of a bookmaker to any customer appearing to be a problem gambler, first to take reasonable steps to offer assistance, including but not limited to a self-exclusion arrangement, and second, to avoid unconsciously, by carelessness, exploiting the customer's vulnerability by permitting that customer to continue gambling. Now, this broad version of a duty of care was rejected by the trial judge, and unfortunately, there was no appeal on that point to the Court of Appeal. I'm going to come back to this and to the judge's reasoning because it's central to the argument I'm going to develop. Developments in the last 15 years, both in the law and in the gambling market, lead me to think that this broad duty of care is now both appropriate and should not be particularly controversial. But let's just finish the saga of Graham Calvert's litigation first. So the judge has rejected the broad duty of care, but accepted the claimant's narrow formulation of a duty of care, derived from William Hill's specific assumption of responsibility to Mr. Calvert in agreeing to put the self-exclusion in place. William Hill's employee then totally failed to do so, which amounted to a breach of that common law duty of care by allowing the claimants to continue gambling. So it's looking good so far for Mr. Calvert. Nonetheless, his claim was unsuccessful. This is because the judge was convinced that if William Hill had done what it should and self-excluded him, or excluded him, Calvert would simply have gambled and lost equivalent sums elsewhere. Mr. Justice Briggs said that this meant there was no causation between the defendant's breach and the claimant's loss. He said this: the claimant would ultimately have ruined himself financially, albeit at a slower rate, concluding that he would have ruined himself by the end of 2007. The Court of Appeal agreed with this conclusion, though adopting slightly different reasoning that we don't have to worry about. Now, as that quote shows, ruined himself financially, although the judge allowed the amendment to the pleading, the case was still treated as essentially one of pure financial loss. The personal injury claim, the deterioration in Calvert's gambling disorder as a result of the defendant's breach, got lost in the mix. Of course, this didn't ultimately matter because the whole claim failed. But what should happen now? So, one of the things about Calvert is the timing dimension. It now seems both legally and technologically completely out of date. First of all, why is it legally out of date? Well, I think it's legally out of date for 2 reasons. I think the assumptions that drove the outermost reaches of the common law position have been undermined by 2 legal developments since Calvert. The first, and law students in the room will probably know what I mean without me having to explain it, and I'm not going to explain it. Suffice it to say that in the last few years, the Supreme Court has re-emphasised the central importance of a basic binary distinction in the law of negligence. The distinction between causing harm, that's making things worse, and failing to confer a benefit, or not making things better. The former is much more readily covered by the law of negligence, and a duty of care is the default setting. In contrast, the latter only exceptionally gives rise to a duty of care. It's the difference between driving over someone and watching someone step in front of a car without shouting a warning. Failing to confer a benefit is only actionable in certain circumstances, certain exceptional circumstances, one of which is if the defendant assumed responsibility for the claimant's welfare, though there are other exceptions. And it was this assumption of responsibility reasoning that was the judge's focus in Calvert. And I think his outermost reaches quote reflects the framing of the facts as sort of doubly exceptional. Failure to protect someone from causing themselves pure financial loss. Now, as simple as this binary distinction sounds, it actually can be extremely difficult to draw in practice. And I think this case was no exception. William Hill failed to stop Calvert from gambling, but as a result, as the judge accepted, his gambling disorder worsened. So one might say that strictly, it's an actively causing harm or making worse case. And it's a personal injury case, just as it would be if tragically Mr. Calvert had taken his own life as a result of a gambling disorder, worsened or caused or worsened by the defendant's wrongdoing. So on the view of the current Supreme Court, this should mean that a duty of care is the default setting, that the defendant should be having to justify an immunity from negligence liability. I should add that even in failure to protect cases where there's a no duty default setting, sometimes an exception is recognised. And we see that in custodial cases. So the police have been held liable for failing to prevent an already suicidal person, otherwise said to have been of sound mind, from committing suicide in police custody. So my first suggestion is that Mr. Justice Briggs didn't quite divide his approach in the way that the Supreme Court insists upon today. Secondly, spoiling my slides. Secondly, that's it. Secondly, Calvert is out of date because of a much more significant legal development, the Gambling Act 2005. Now, the facts of Calvert occurred in 2006, in what you might call the liminal space between the Gambling Act being given royal assent in 2005 and its coming into force in 2007. So Calvert was really out of date by the time it was decided. On its particular facts, this is important. If the equivalent facts arose today, Calvert would seek self-exclusion via compulsory schemes that involve all licensed gambling operators. So there's something called GamStop, which prevents someone who's registered with their scheme from using gambling websites and apps run by companies licensed in Great Britain for a period of their choosing. Or for land-based and telephone gambling, there's a MOSES scheme, multi-operator self-exclusion scheme, which allows someone to self-exclude from multiple bookmakers. So today, on the facts of the case, Calvert would win. But more generally, the Gambling Act transformed gambling in the United Kingdom into the largest regulated market in the world. This contrasts with many other common law jurisdictions. For example, online gambling remains illegal in most US states. Seems extraordinary to us. Previously subject to tight legal restriction, for example, gambling debts were unenforceable. Some of you old enough to remember, some of us old enough to remember that bookies were required to have blacked out windows, for example. Previously it was like that. Now gambling has become a mainstream lucrative leisure industry. The Gambling Commission is the regulator and licensing body, presiding over a detailed regulatory regime, one that is meant to ensure social responsibility. So I think it's legally out of date. It's also technologically out of date. There's another incredible timing irony. While the drafters of the Gambling Act worried about super casinos, worried about banning slot machines in taxi offices and chip shops, the first iPhone was introduced in the UK in 2007. So we've gone from this to this. The smartphone made Graham Calvert's telephone betting and the Gambling Act scheme for licensing casinos seem antediluvian. As Rob Davies says in his superb book, Jackpot, now everyone has a super casino in their pocket, open 24/7. And he cites a political critic describing the Gambling Act as an analog solution to a digital problem. So this digital problem would have been unimaginable even to the parties in the Calvert litigation 15 years ago. The innovations of the digital age have brought an inexhaustible supply of new products, fixed odds, that's hard to say, fixed odds betting terminals in bookmakers, online casino games, instant in-play betting on sporting events. Unlike naturally occurring products such as nicotine and narcotics, these products are designed and modified to encourage addiction. Using cleverly refined techniques as to the speed and design of play, visual tricks and accompanying graphics and musics, they exploit the heuristics and errors in normal human behavioral psychology. Natasha Schull, in her groundbreaking book about machine gambling in Las Vegas casinos, describes these machines as addictive by design, showing how data gathered from casino floors is used to adjust payout schedules in order to maximize gamblers' playing time. This data from casinos, huge human laboratories about how to best manipulate human behavior, is then translated into online and gaming machine product development. These highly addictive products are then promoted by overwhelming advertising, and robust studies have traced a link between advertising and more frequent and riskier gambling. Banks and Waters, criminologists who explored the gambling industry through the lens of state corporate harm, wrote that consumption cues which promote gambling as a glitzy and glamorous transformative experience that results in economic and social riches have serious repercussions for how individuals understand wagering activities. In turn, such understandings can shape individuals' gambling behavior and increase their susceptibility to the numerous harms posed by gambling. And there's something new: aggressive, personalized targeting of individuals with emails, tweets, social media messaging, and so on. Gambling companies have access to vast amounts of real-time data about customers and their transactions, and use data profiling software to monitor customers. Where the software detects that a frequent gambler has gone offline for a while, its artificial intelligence can determine their level of addiction and see if there's someone to try and win back by targeting, for example, with so-called free bets, not so very free, £50 if you bet £100, for example, or other inducements. Dostoevsky's novella, The Gambler, published in 1866, describes being in the grip of overwhelming gambling addiction, and he wasn't subjected to today's targeted strategies and high-speed addictive products. Anthropologist Rebecca Cassidy, in her brilliant book, Vicious Games, quotes a betting shop manager talking about fixed odds betting terminals with a certain suggestion of glee. He said, "Honestly, most people try them and that's it. Hooked!" exclamation mark. Some of the really egregious behavior comes from so-called VIP schemes. These involve an employee of the gambling company working on commission, making personal contact with a customer as their personal account manager, sending gifts and inviting them to sporting events, at all times enticing more gambling with free bets and other incentives, including loyalty rewards programs. So the more they spend, the more free bets they get. These schemes focus on players who are staking and losing large sums. You are soon ditched from the scheme if you start making money. One company reported that 2% of its customers were VIPs, but they accounted for 83% of its profits. Lydia Thomas, an investigative journalist for BBC Radio 4's File on 4, told the House of Lords Select Committee that customers I have spoken to say they feel groomed to spend more by the gambling company. These schemes have in the past been responsible for some serious breaches of the Gambling Commission's Code of Practice and licensing rules, triggering significant fines. I should add, it's now recognised by all political parties that in the modern digital world, the Gambling Act regulatory regime is inadequate. And in December 2020, the government called for a review. Unfortunately, the white paper proposing reform has been repeatedly delayed because of COVID, but also by changes in prime ministers and what's been called the revolving door of the Secretary of State for Culture. It is apparently imminent. I was extremely worried it would be this morning, but it's not. What emerges will undoubtedly tighten regulation and improve the public health response to gambling, including severely restricting, if not banning, VIP schemes. But the rumour is it still won't provide for civil liability, for compensation for those harmed by wrongdoing by the gambling companies, ignoring a recommendation to that effect from the House of Lords Select Committee. So we can expect larger and more frequent fines imposed, not one penny of which will go to the victim or their families. So gambling is now recognised as a major public health issue. Before we return to the law, just a word about how the debate about gambling is framed. For gambling companies, it's a legitimate market-driven leisure activity, benefiting from laissez-faire, light-touch self-regulation, antithetical to intervention from the nanny state. This views gambling as morally neutral and is seen in the labelling of problem gamblers. A small number of weak individuals are the problem, not the industry itself. It was their choice to start gambling and their choice and their fault that they become addicted. As long as we push a responsible gambling message, they're not our problem. Davies describes this as an approach straight out of the playbook of tobacco manufacturers, and one might add, straight out of the playbook of the manufacturers of OxyContin. For Cassidy, freedom to choose became sovereign, and attempts to limit the exposure of people to harmful products could be presented as an arrogant and patronising act of contempt. This seems to me to be part of the narrative that supports the outermost reaches line, to suppress examination of the industry against the norms of private law, individual rights and duties. But here's the thing, quote from me, just because a particular activity has an individualist laissez-faire philosophy doesn't oust or diminish the role of the common law. The clue is in the word individuals, some of whom suffer serious harm. The player, also their partners and families, friends and employers. Just because we've moved to a world where gamblers are now anonymous account holders or data points doesn't trump the normative force of the law of negligence. I bear the costs of harms I suffer unless they were caused by the wrongdoing of someone else, whereupon it is right that the costs should be shifted to them. So, with all this in mind, let's go back to Calvert and reanalyse Mr. Justice Briggs' rejection of a broad duty of care owed by gambling operators to their customers with regard to gambling disorder, to see if his reasoning survives these legal and technological developments. And I've displayed the language pleaded by Calvert on the slide there. So what did Mr. Justice Briggs say in order to reject this broad duty of care? Well, the first thing he did was to reject the claimant's argument that William Hill assumed responsibility to anyone with a gambling disorder by adopting its social responsibility policy. I'll give you two of his reasons. The first was, it's unrealistic to suppose a bookmaker can be expected to identify pathological gamblers who can't control their gambling. Well, that might have been true in 2006. A telephonist in William Hill's call centre might not have been able to identify someone with a gambling disorder. But nowadays, as we've seen, the company's software does it scarily well. If artificial intelligence can detect someone whose gambling is out of control in order to target marketing at them, they could easily do so to meet the broad duty of care. Secondly, Mr. Justice Briggs said, well, if the if William Hill's employee had activated the self-exclusion agreement as he should have done, this would have included an express disclaimer of liability. And a disclaimer is inconsistent with an assumption of responsibility. My answer to that is, we're framing this debate as an assumption of responsibility for making gambling disorder worse, a personal injury claim, as opposed to a pure financial loss claim. And as everybody knows, businesses are prohibited by statute from excluding liability for personal injury caused by their own negligence. But taking a step back, there's a more general objection to the whole premise. Assumption of responsibility is simply not needed for the mainstream fact pattern where the defendant acts negligently and causes personal injury to a claimant. Assumption of responsibility gets wheeled in as a trump card where the default setting is no liability. That's why it's needed for claims for pure financial loss, and that's why it's needed for claims where the allegation is that the defendant failed to protect or help the claimant. But it shouldn't be needed where the allegation is that the defendant's breach worsened the claimant's gambling disorder. So the judge allowed that amendment to the pleading, but then didn't quite follow through with it in his reasoning. So rejected the argument that there was an assumption of responsibility. He then turned to the familiar, well, they're familiar to the lawyers in the room anyway, the familiar Caparo factors, which must be met whenever it's proposed to extend the duty of care to a novel factual situation. There are 3 of them, for the benefit of those who are not au fait with English law of negligence. The first was there foreseeability of damage? Well, yes, of course there was, but there always is. So we can move on for that. Second requirement, a relationship between the party owing the duty and the party to whom it is owed, characterized by the law as one of proximity or neighborhood. On this, he said, the law should be very slow to recognize a sufficient proximity to justify a requirement to take protective steps to restrain a gambler from exercising his liberty to gamble on his own responsibility, where his status as a problem gambler may mean no more than that he is experiencing mild and occasional difficulties of control. Again, I emphasize that the broad submission assumes a duty of care to all problem gamblers, regardless of whether they seek the bookmaker's help. Well, my response to that is that it smacks of an unfortunate version of the floodgates argument, whereby just because there might be a large number of potential claimants, that somehow lessens the defendant's responsibility. I mean, each individual gambler is in a contractual relationship with the defendant, much greater proximity than is usual in a purely tortious negligence claim, particularly given the individual targeting that gamblers now experience. And remember, we're talking about a personal injury claim, albeit in the form of psychiatric injury and ultimately, tragically, sometimes suicide. So I don't buy his rejection of the proximity requirement. The final one, the third one, is that the situation should be one in which the court considers it fair, just and reasonable that the law should impose a duty of a given scope upon the one party for the benefit of the other. The fair, just and reasonable limb that includes a very rich analysis of all sorts of policy arguments. And again, Mr. Justice Briggs said, no, this isn't satisfied. It wouldn't be fair, just and reasonable for there to be a duty. And he said this because a broad duty would place a burden on the bookmaker, pursuant to which the problem gambler could freely take home his profits, but look to the bookmaker for the return of his losses, without even seeking the bookmaker's assistance to help him control his gambling. Well, that's a specifically pure economic loss, pure financial loss argument, so it doesn't really address the worsening the gambling disorder point at all. But even in its own terms, I'm afraid this argument doesn't convince me either. As the House of Lords Select Committee pointedly said, we have little sympathy for an operator who has to pay winnings when the reason for this is simply his own failure to give effect to a self-exclusion agreement. The same could be said for all sorts of other breaches by a defendant. And there's a further counter-argument, it seems to me, which is that gambling companies don't let people carry on gambling if they're winning. Cassidy describes this as a business model based on attracting and retaining losing punters and turning down business from winners, whereby gambling companies have downloaded the risks generated by their products onto their customers. So I find it hard to accept the 2008 rejection of a broad duty of care owed to gamblers in respect of the development or worsening of gambling disorder, with consequent financial loss and potentially suicide. I think a broad duty of care should not be exiled to the outermost reaches of the common law, but should be rehabilitated into the mainstream. Its scope is appropriately limited, owed to those whom the defendant knows or ought to know are slipping into addiction and gambling disorder. Now, it's tempting to call for liability for addictive products per se. It's just unreasonable to market them full stop. But I don't think the incremental approach to common law development would allow that anytime soon. It is, though, worth noting that if people were being harmed in this way by a tangible product, like a medicine, a detergent, or a cosmetic, they wouldn't even need to invoke the law of negligence to recover compensation at all. We have a statutory regime derived from Europe of no-fault liability for dangerously defective products. Maybe the expansion of this regime will be the focus of future reform proposals in response to the intangible dangers of smartphones, social media, gambling products, and so on. But for now, we will continue our focus on the law of negligence. So we're now going to look at the remaining elements of the negligence cause of action. The first is breach of duty. Establishing a duty of care is just the beginning of the analysis. There can be no liability unless it's breached. It's so obvious, it oughtn't to be worth saying, but a lot of people think the analysis stops at duty of care. It doesn't get nearly enough academic attention. As my colleague Simon Deakin has written, in the context of negligence claims against social workers carrying out their child protection function, a jurisprudence focused on duty inevitably means that a more nuanced account of what amounts to fault or breach in complex settings such as this will be slow to emerge. But let's try and do it. The breach in Calvert was straightforward because of the narrow nature of the duty of care that was accepted. The defendant agreed to self-exclude the claimant, then didn't do it. But if we're adopting a broader duty of care, how will we test breach? Well, one place to start is the House of Lords Select Committee recommendation that we should adopt the breach of statutory duty tort, focusing civil liability on breach of the Gambling Act's provisions, its codes of practice and licensing conditions. That way, gambling companies would know that if they obey those rules and conditions, there'd be no liability. The law of negligence tests breach slightly differently. The test is whether the defendant behaved reasonably or came up to the standard of reasonable care judged objectively. So the test isn't, did the defendant breach a code of practice? But if they did breach a code of practice, that would be very persuasive evidence of unreasonable behaviour. This would certainly catch the various well-publicised instances of fines rendered by the Gambling Commission, currently not attracting concurrent civil liability, each of which was a truly shocking account of gambling companies causing or exacerbating gambling disorder by flagrant breaches of their codes of practice. Last September, Betfred was fined £2.9 million over failings in its social responsibility and money laundering controls after accepting vast sums of money from customers with no safety checks at all. One customer of ordinary income was allowed to lose £70,000 over a 10-hour period just a day after opening their account. Elsewhere, Ladbrokes and Paddy Power allowed a customer who'd been left seriously disabled and brain injured by medical negligence to gamble away the compensation that they knew was his only source of income. The civil courts have occasionally had the opportunity to examine breaches of this kind. Mr. Justice Griffith's judgment in the Deer and Flutter Entertainment PLC case, which was a claim by the gambler's employer to try and recover money from the gambling company that the gambler had stolen from his employer, And the judge's judgment was contemptuous of Paddy Power's VIP scheme, which failed to do any investigation into the source of the gambler's apparent riches. The judge said this: witnesses stonewalled, denying that there was a breach of policy, or that the policy itself was inadequate, or that allowing and positively encouraging months of high-stakes gambling before even seeking, let alone obtaining, satisfactory evidence that Mr. Parante, the gambler, could afford it or had legitimate sources of income or wealth to pay for it, was wrong. That's a long sentence. I'll just remind you of the syntax. They denied that all these things were wrong. In my judgment, he said, Paddy Power knew that it was dealing with a compulsive gambler who could not afford what he was doing, and Paddy Power did not really care. Now, as I've said, at common law, failing to comply with industry codes of practice or licensing conditions is highly persuasive evidence of breach. But ultimately, the test is whether the defendant failed to come up to an objective standard of reasonable care. And that might be helpful because occasionally the courts conclude that someone who followed their industry's universal common practice was nonetheless in breach. Happened in one of my favourite cases, an infamous example when the Privy Council condemned universally adopted conveyancing practice in Hong Kong as nonetheless unreasonable, and therefore the defendant that followed it was in breach. And this leads me to quite a useful comparison that can be made with how breach is tested in stress at work cases. I think they're analogous because they involve the infliction of psychiatric harm where the parties are in a contractual relationship, this time one of employment. The court's approach mirrors the broad duty of care that I've accepted, and also provides a model for testing breach. Lady Justice Hale, as she then was, formulated the test as follows. Unless the employer knows of some particular problem or vulnerability, an employer is usually entitled to assume that his employee is up to the normal pressures of the job. So that means that when they do know, that's when their responsibility kicks in. And this was applied to the claim by a school teacher in the Barber case. This man had been driven to the verge of collapse by being dumped with an unimaginable, unmanageable workload. So he asked his employer for help, but nothing changed, and his mental health collapsed, and he had to take early retirement for ill health reasons. The House of Lords held that his employer was liable because they knew, once he'd gone to ask for help, they knew that he was vulnerable. As Lord Walker said, even a small reduction in duties might have made a real difference. VIP schemes will have this sort of individual knowledge, which I think would include what lawyers called blind eye knowledge, the idea of deliberately putting the telescope to your blind eye. Not if you don't look, you don't know. Moreover, as we've seen, gambling companies have the artificial intelligence software to recognize patterns and detect gambling disorder, which they use for targeting inducements. So it's possible to imagine breach of our common law duty of care extending beyond breaches of the various statutory codes of practice. So that's just a word on breach. Let's now turn, something wrong with this. Hey, too many arrows, never mind. The next thing you have to show if you want to establish liability and negligence is what we call factual causation. And this is potentially, I think, going to be the hardest part of the cause of action to establish, although I don't think it's impossible, because the claimant needs to show not just that gambling caused their harm or that the defendant caused their harm, you've got to show that the defendant's breach caused the harm. The standard test that works fine in most situations is the but-for test. So where the defendant drives like a lunatic and smashes into the claimant's leg, it's obvious that but for the defendant's negligent driving, the leg wouldn't have spontaneously exploded just at that moment. The leg was fine before the tort, now it's not. By analogy, in our context, I think the most straightforward causal link to establish, putting to one side the gam stop, the actual facts of Calvert, which I think would now be entirely straightforward. The most straightforward causal link would involve a victim with no history of any psychiatric harm or other addictive behaviours or comorbidities prior to the breach. Perhaps someone who became hooked as a child, where the relevant breach was letting them start gambling in the first place and get hooked. What about our Calvert fact pattern, where the defendant's breach made the claimant's existing gambling disorder worse? Well, the law certainly allows contributing to or worsening an existing condition as satisfying the relevant causal test. Though the problem is then shifted to the stage where you're quantifying damages. How do you work out which bit of the claimant's eventual position should be the financial responsibility of the defendant? But a good example is the stress at work case I just mentioned. Mr. Barber recovered damages for his breakdown, even though the defendant's breach was just the straw that broke the camel's back. His mental health was already fragile by virtue of stress at work that wasn't tortious. So the House of Lords didn't say he loses, they said he wins, but we deal with it at the quantification stage. They say we take account the chance that if he had continued with a similar teaching job, his health might have broken down in the same way. I've never seen an equivalent suggestion in a case involving suicide, not even in the police custody case I mentioned earlier called Reeves, where the claimant who took his own life in police custody because the police negligently failed to trigger the suicide watch procedure, he was already suicidal on arrival in the cells. There didn't seem to be any examination of the impact of that on his family's claim. But I think the more difficult issue in our fact pattern might be the more abstract and in fact, the prior one of establishing that unreasonable gambling practices are capable of causing or contributing to gambling disorder at all to the satisfaction of the legal standard of proof. Statistical connection doesn't suffice for causation. This may sound utterly extraordinary and counterintuitive, but I'm afraid there is a bleak analogy in the history of tobacco litigation in the United Kingdom. The only UK case to reach trial, as far as I know, was a Scottish first instance decision called McTeer and Imperial Tobacco. It's 350,000 words long, longer even than Ulysses. So there we are. I've never seen anything like it. And the fact is, the claimant, the widow of Mr. McTeer, who died of lung cancer, failed on every single point. It was an unbelievably, extraordinarily defendant-sided decision. The judge found, amongst many other things, that Mr. McTeer's widow had not proved that smoking causes lung cancer, a conclusion described by one commentator as an unworldlily high standard. Is that an adverb? I'm not sure. But anyway, an unworldlily high standard and an extraordinarily easily escape route for a corporation. Well, I hope that factual causation would be easier in our context, because only one thing causes gambling addiction, and that's gambling. So we would face none of the epidemiological problems associated with showing causation in tobacco or industrial disease litigation with complex disease etiology. Nonetheless, what will count will be the robust scientific studies now being commissioned to demonstrate the mechanisms by which gambling disorder develops and worsens. There's an awful lot more I could say, but in summary, I think the factual causation hurdle is likely to be tricky, but not insurmountable. Next, we need to consider scope of liability for consequences, traditionally called legal causation, but I think that's confusing as a label. What we're talking about here is the normative value judgment that determines whether, despite being in breach, despite that breach being a factual cause of the claimant's harm, the defendants should nonetheless be exonerated. And this is the place in the analysis in which I think gambling companies will emphasize the problem gambler rhetoric. Even though we're at fault and even though our fault caused your harm, nonetheless, you decided to continue, even decided to take your own life. You were the author of your own misfortune, a phrase you may not be surprised to hear also used by the judge in McTeer, the tobacco litigation case. I actually don't see that argument as likely to succeed. The simple reason, it is a simple reason, is that this harmful narrative should have no currency in a negligence claim involving gambling disorder because it doesn't apply to claimants whose autonomy was impaired as a result of the defendant's breach. In a House of Lords case from 2008, funnily enough the same year as Calvert, called Core and IBC Vehicles, Mr. Core suffered a horrific injury at work as a result of his employer's negligence. His ear and the side of his head was completely sliced off. Before the accident, he'd been a happily married, easygoing man. But after it, he developed depression, unsurprising as he was left with post-traumatic stress disorder and chronic pain. His depression worsened and did not respond to treatment, even electroconvulsive therapy. 6 years after the accident, tragically, he took his own life. His employers tried to deny responsibility for Mr. Core's death on this basis. But the House of Lords rejected their argument. As Lord Bingham said, Mr. Core's suicide was not a voluntary informed decision taken by him as an adult of sound mind, making and giving effect to a personal decision about his future. It was the response of a man suffering from a severe depressive illness which impaired his capacity to make reasoned and informed judgments about his future. Such illness being, as is accepted, a consequence of the employer's tort. It is in no way unfair to hold the employer responsible for this dire consequence of its breach of duty. Well, I hope that suicide by someone overwhelmed by gambling disorder would be treated in the same way. Sadly, I have no time, I'm not even looking at the clock, I have no time to discuss all the possible defences to a negligence action, such as illegality. Could a claimant who stole money in order to feed their addiction claim damages to compensate them for being incarcerated in prison, for example? No time to talk about limitation. That's the time limit. And in order to understand the time limit, you need to know where the cause of action begins, and that can be tricky. Nor have I got time to consider the quantification of damages or vital procedural issues such as costs and disclosure of documents. But I do want to mention just one more issue that I feel strongly about. The defence of contributory negligence. So contributory negligence is a partial defence, which means that the damages the defendant has to pay are reduced if the claimant was also partly to blame for their injury or loss. In the words of the statutes creating this defence, where they suffered damage partly as a result of their own fault. Things like a negligent driver drives into your car and your injuries are worse than they would have been because you weren't wearing a seatbelt. Now, the contributory negligence defence wasn't pleaded by the employer in the Core case. That's the case where the poor man's ear was sliced off and he eventually committed suicide. But some of the law lords commented that if it had been pleaded, they would have supported a reduction in the damages payable to Mr. Core's family for his fault in committing suicide. Now, I know where they got that idea from. In the other fact pattern case, Reeves, where the defendant didn't make the claimant suicidal. He was already suicidal when he came into police custody. They merely failed to stop him committing suicide. The House of Lords wanted to come up with a way of really dividing responsibility between the police and the man of sound mind who took his own life. And the only legal mechanism they had to do that was to find the deceased 50% to blame under the contributory negligence legislation. I can just about buy that, where given that he was already suicidal on arrival. But I have to say, and I won't labour this, but one of the things I find the most deplorable in this area is the suggestion that suicide triggered by severe untreatable psychiatric illness caused by the defendant's wrongdoing should be treated as the sufferer's fault. I think that's unacceptable. So this is all very well. I've run you through my view of how the cause of action might work. But to close, why does it matter? What's the point of clamouring for civil liability for gambling disorder? Well, I think there are several reasons. Most obviously, it brings financial compensation for a sufferer, or if tragically they've taken their own life, for their estate and their dependents. Deterrence is also important. The House of Lords Select Committee said the current legal and regulatory context does not sufficiently deter gambling operators who stand to benefit from allowing problem gamblers to lose money. In short, they make more profits than the fines they're required to pay. Then there's discovery of documents. Getting your hands on the sort of secret inside information that the companies have about how their business works. One of the most significant long-term benefits of tobacco litigation in the USA was the compulsory discovery of documents from the heart of the industry, otherwise guarded with considerable secrecy. I think the same would apply here. Finally, I think there's a symbolic importance, a recognition of the role of the common law in a civilized society. No corporation, no individual should be too wealthy or too powerful to enjoy immunity from its scrutiny, its standards of reasonable behavior. To conclude, can we think beyond negligence? So the tort of negligence, as we've discussed, with its focus on defendants who fail to come up to an objectively reasonable standard and which breach causes reasonably foreseeable loss, serves us very well in so many contexts. And I think it can be of use in gambling disorder and consequent suicide, no longer thought of as situated in the outermost limits of the legal galaxy, but it isn't straightforward to map its fact pattern onto our requirements. And it occurs to me that the common law is very good at protecting individualist values when they involve money and property, even, dare I say it, the right of someone who owns a glass penthouse not to be overlooked. In the gambling market in the UK, we see individuals viewed as units of profit generation. Ironically, the common law already responds to that designation where it's the profit that's under threat. So if Ladbrokes intentionally induced the CEO of Betfred to breach his contract of employment and come and work for them instead, they'd be liable to Betfred in tort for substantial damages for intentionally inducing a breach of contract. Maybe we should propose a new tort. Only an academic can say this. A practicing lawyer could never say it. Maybe we should propose a new tort. Intentionally or recklessly inducing or exploiting gambling disorder. In the 21st century, we face industries, particularly but not exclusively gambling, with the ability to tailor their products and target individuals for vast profit, with a blind eye turned to the collateral damage in terms of lives blighted and tragically lost. I hope that the common law can rise to the challenge. Thank you very much.
I told you you would get a lecture that made you think in a different way and understand in a different way an area that was being looked at. That was wonderful.
Thank you.
Absolutely wonderful.
Thank you.
So we have time for questions, both online and in the room. I'm going to take a couple in the room while I work out who's online and asking questions. So should we start in the room?
Addressing the point at the end where we're looking beyond negligence, I'm aware that there's a matter that's listed for trial this year, which actually deals with a lot of the evils raised by the Calvert claim from the perspective of breach of contract. So essentially arguing that individual contracts for specific bets would be void where the gambling company were on notice of gambling related harms. And so I wonder whether what you think about the extent to which that might be viable from the perspective of financial loss. Of course, we've got to leave aside personal injury and suicide there, but the financial loss in respect of each contract claim.
It's hard to see how you could make a claim for financial loss, which would have to be a claim for breach of contract, at the same time as avoiding the contract. They're two inconsistent responses. But I wish I'd had time to talk more about the contractual context of all this, because it's very important. Another legal development, which got crossed off my list when I worked out the time constraints, is the Consumer Rights Act. And probably not Mr. Calvert, I think he was a professional gambler, but most claimants would be consumers. And I think that's an area that deserves looking at. There's a very nice, the irony is that if you're winning and you look to the common law, you do quite well. So there's a nice case a year or so ago where a chap appeared to win over £1 million on a Frankie Dettori casino game run by Betfred, and they tried to argue that there was a malfunction and that there was a clause in his contract with them that said we don't pay out if there's a malfunction, and they lost in every possible way. They lost for common law reasons, which was that this clause didn't cover the point anyway, and in any event it hadn't been drawn to his attention. And then the judge hit them with the Consumer Rights Act and said, this is a contract for the supply of a digital product, and this is an unfair term. So he got his money. So there's another irony that the common law seems to help you quite nicely if you're winning and the gambling company wants to take it away from you. The reason it wasn't, I tried to see why, because if it was a contract for services under the Consumer Rights Act, then there'd be a statutory obligation of reasonable care, and you could do it that way. But the judge said it was just an individual betting contract, so it wasn't a kind of a series of contracts that you could argue was the provision of services. I'm not sure whether that's right. It didn't matter on the facts, but it's a really, yes, and unconscionable bargains and all sorts of things. But thank you, that's a great question.
While you think of more questions, I want to roll two from the internet up together. So the first one says, do you think it will be possible to ban gambling apps such as the Lotto app? So banning them. And then the other question is in the same kind of vein, different area. What about putting adult gaming centres wanting to be 24 hours in deprived areas? What could we do to limit that happening?
I have to say that I think dealing with, certainly the best way to ban something is not to use the common law. I don't think that what I've been talking about could be used to ban anything. And I hope that the white paper, when it finally arrives any day now, will consider that sort of tighter regulation. Putting gambling centres, 24-hour gambling centres in deprived areas. You could. It's hard to see that the common law, as opposed to the regulation, could respond to the putting it there in the first place. But it wouldn't take much if my scheme is adopted to say that the first person that walks through the door and doesn't have very much money, they as soon as they fall into patterns of disordered gambling, the company should be liable. But I'm not sure that's what the questioner is asking. I think the focus on banning things needs to be a regulatory one, with fines to back that up. This gentleman here.
We are not going to have time for all these questions, but can I take one here?
Do you want the microphone?
And then perhaps one more before drinks.
Maybe
I know that leaves a lot of you unable
we can
to
talk
ask
over
questions,
the
but
drink.
you can talk over drinks.
Thank you. My name's Martin Jones. In talking to the public at large, I find that not many of them understand gambling harm, so I suspect that might also be true of lawyers. So I'll just give you a couple of insights. One, if you get the chance to Google Professor Knott and Tony Franklin, and also the Paul Merson documentary, you'll see what it does to the brain, effectively rewires it. So that seems to me my sense of the legal profession is that they assume the gambler is of sound mind and capacity, just making poor decisions. That may be a mischaracterization, but if you want to know what's really happening in the gambler's brain, take a look at those two. Throughout my working life, the Health and Safety at Work Act and the duty of care that instilled on me as an engineer to do everything reasonably practical to prevent harm on my construction sites in the workplace focused my mind beautifully, and it kept me awake at night sometimes. Do you think that statutory duty of care would be a better way forward to prevent gambling harm rather than common law.
Thank you.
And there are parallels. The FCA have just introduced a duty of care onto the finance sector to protect vulnerable. There may be one in the gambling harm, also in the online harm sphere as well. So that seems to have got some legs to me.
Yes. Thank you. I mean, on your point about the potential of these products to rewire the brain, that was absolutely crystal clear to me as soon as I started to read about this. And indeed, all of us in the room know the feeling of scrolling through your phone and not really knowing why you're doing it, but not being able to stop. And if you multiply that by 1 million, you begin to get a sense, I think, of what we're talking about. I think lawyers will understand it. The trouble with lawyers is that they plead the case for the client that they're instructed by. Yeah, I mean, the suggestion that we have a breach of statutory duty tort off the back of the statutory regulations that exist in the Gambling Act is, I mean, it's very workable, and I think it's probably has more likely. I mean, it's something that could be in legislation in a way that what I've tried to do, and expanding it through Calvert isn't the focus of legislation. I was trying to make the point that that's actually quite restrictive, because a common law claim isn't tied to breaches of the particular prohibitions and so on. But it may well be that it stands more of a chance of ever being adopted. I don't know whether you've heard, I mean, I read that the government has sort of subtly ditched that idea. Is that right? Yeah.
I talk to politicians now and again. My sense is none of them are pitching that in their top 10. It's my top ask.
Okay.
And I think that's really because they're politicians and they're looking for a quick win. And statutory duty of care will need legislation and will probably happen after the next election. So let's not.
Okay.
Let's go for the low-hanging fruit. I think that's a real politic issue.
How depressing. Yeah.
Absolutely.
Yeah. Thank you. Oh, one more. Can we have one more?
We can have one more, but there were a lot of other people around, and
It's Jonathan. There's one right
I
at the back.
thought there was one female student.
Oh, yes.
So
That's not a student. That's an
might not
academic.
be not a student, but I thought somebody would be here.
Hi, thank you very much. It struck me when you were talking about Calvert that possibly a more modern way of pushing at the edges of that might be to tackle it as an autonomy-based issue. So we've seen that in some medical cases with privacy and data protection, i.e. loss of autonomy, trying to frame that as damage in itself. That would seem to solve some causation issues, but obviously we've got issues with recognising autonomy as damage and negligence. I was wondering if you have any sort of thoughts on that, or, I mean, do you just view that as a completely closed route?
It's not something I've thought about. Thank you. That's an interesting suggestion. I suppose it just seems to me so intuitively a really horrific sort of personal injury, albeit not one where you've been hit by a car, but you know, in the way that the common law has managed to embrace depression and post-traumatic stress disorder. I'm never sure about these shimmies that say the damage is actually, you know, loss of a chance or lost autonomy or something like that. And you get into all sorts of tangles when you then try and work out the quantification of damages, because it doesn't, you know, how come the loss flows from the loss of autonomy? So it's not, maybe I'm too old-fashioned, but it's not something that I think is the way to go. But it's a really interesting thought. I mean, in any, you know, we all know when something's pleaded, the more things you can throw at the court, the better. So it's certainly not something I'd rule out, but I don't think it would be my kind of primary focus.
So I am going to close it there because time is up, and both of us are standing between you and drinks. But I just want to say it's one of those public lectures that I think the test of a public lecture is that it infiltrates your conversation over the next week or so. You won't be able to resist telling your friends, do you know what I heard a couple of nights ago? We've had one of those. So thank you very much.